Good morning, everybody, and thank you very much for attending our webinar this morning. Your presenters today will be me, Richard New. For those who don't know me, I'm a partner in the real estate disputes practice here, and I'm joined today by Chris Brand, who is one of the associates in the real estate disputes team as well. For the eagle-eyed amongst you, it hasn't escaped our notice that your presenters today are Brand and New. So please, no hilarious comments in the Q&A box. We've already had plenty of that. In terms of housekeeping, there is a recording available afterwards if any of you miss any of it or want to go back and look at something after the event. And also, please feel free to send a question through in the Q&A box as we're going along. We've had a series of questions already sent through in advance. If your question doesn't get answered, if you do want to put your name in the Q&A box when you send your question through, we'll do our utmost to email you or get in contact with you after the event and answer your question. Next slide, please, Chris. And can you actually put on one more? Thank you. So this is the first in a series of 3 seminars headed Blank Slate, and it's all about empty space. So it's a sad fact of life at the moment that a lot of landlords have got more space on their hands than they'd like. And a lot of corporate occupiers are assessing their need for bricks and mortar and are potentially looking to divest themselves of some of their properties. Now, there's lots and lots of technical webinars going on at the moment. This is a series of short, unashamedly high-level seminars aimed at this topic of empty space. Today, Chris and I are going to be talking about termination of leases, so exit strategies for both landlords and tenants. So Chris will be looking at things more from a tenant's perspective, and I'll be looking at things more from a landlord's perspective. And without further ado, we'll kick off, and I'll hand over to Chris.
Thank you, Richard. So I'm going to talk very briefly, first of all, about break clauses, predominantly from a tenant perspective. So we know the basics. A break clause can be included in a fixed term lease, allowing either the landlord or the tenant to terminate the lease early. The right to break may arise on one or more specified dates, or it may be exercisable at any time during the term on a rolling basis. A tenant wishing to exercise a break notice must observe a number of issues. Failure to comply strictly with the terms of the break provision will render any break notice ineffective, and the lease will simply continue for its full term or until otherwise terminated. So, a very high-level summary of what a tenant needs to do if it wishes to exercise a break clause and exit a lease. The first point is to check the date on which the break can be exercised. This is often a fixed date, or it might be expressed to be a particular anniversary of the term commencement date. The tenant will need to check what advance notice he needs to give the landlord to exercise the break. This is subject to the terms of the particular lease, but will often be 6 months or even 12 months prior notice. If there is insufficient time to give that amount of notice before the break date, the tenant has simply lost his opportunity to break. The second point will be to check whether the lease stipulates any requirements as to how notices should be served, and whether the lease provides for any deemed service provisions. The contractual stipulations might be mandatory or permissive, or they might refer to various statutory provisions for service. If they are mandatory, then they must be strictly observed. If the break requires service by carrier pigeon, then that is what must be done. Thirdly, the tenant will need to check that it is the correct entity entitled to serve the notice and it is serving on the correct landlord. In the context of registered leases, i.e. generally those for a term of more than 7 years, the correct entities will be those registered proprietors. This is so even if there has been a sale or an assignment which has not yet been registered. If we're within that registration gap, then it is the registered proprietors at the time of giving the notice who are the relevant parties. Fourthly, and these are the most difficult issues, the tenant will need to make sure he can satisfy any conditions attached to the break, and that he can do so at the time required by the lease. Usually a break clause will require various conditions to be discharged at the break date. However, some do stipulate conditions which must be discharged prior to or at the time of serving notice. A common condition is that there are no arrears at the time of the break date. Some tenants fall into the trap that they can unilaterally apportion the last rent payment due if it falls within the middle of a rent period. However, even if they are entitled in principle to a refund of any overpayment of rent, most break clauses will require that the full instalment be paid and any refund dealt with afterwards. Failure to pay the full instalment will mean that the break is ineffective. There might also be a condition requiring a break payment, i.e. a lump sum, to be paid upon the break date or before. The tenant will need to make sure that if the landlord has opted the land for VAT purposes, that VAT has been paid on any outstanding rent and any break payment due. Otherwise, the correct payments have simply not been made. Lastly, in the context of breaks and what's particularly controversial at the moment, where landlords are perhaps reluctant to let tenants go for fear of not being able to find other tenants, a particularly problematic condition is that the tenant give vacant possession. Now, this is harder and more complicated than many tenants appreciate. The presence of under-tenants will obviously mean that VP has not been given, but also leaving on site workmen or security guards, or even relatively insignificant chattels can mean that VP has not been given. Of course, if VP has not been given, the lease will not end. There was a recent relatively controversial case of Capital, which illustrates some of the complexity around giving VP and the interaction with various yield-up clauses in the lease. In that case, a tenant had inadvertently stripped alterations which comprised part of the demise, or decorations which form part of the demise. And the court found that it had not delivered VP of the premises as the premises were defined. In effect, bits of the demise were simply missing. It is an odd case, but it illustrates the complexity around these things and giving vacant possession. That's all I wanted to say on breaks. I'll pass you over to Richard.
Talk about surrender next. Now, you might ask, why in the current climate on earth would a landlord accept a surrender? Well, obviously, we are coming across quite a few of these where a landlord has given careful financial consideration to a tenant's proposal in terms of its longer term planning for its portfolio. So the landlord might think, actually, well, what the tenant's proposing is actually quite a decent deal on rent and delapse, and it might be better off getting the money in my back pocket now than potentially looking at tenant default further down the line. The other thing as well is that actually at the moment landlords are looking at potentially about taking back premises and refurbing or redeveloping, particularly with repurposing as well, maybe changing the use of the premises if it's not currently desirable. Now, as if by magic, those two are actually the topics of our next two in the series of webinars. So the next one's about repurposing of space, and the final one's about delapse and what happens after the lease ends. So I'll leave you to listen to those in the next coming weeks. But in terms of going back to today and the surrender, obviously we would always advise anyone to do a formal agreement and deed of surrender to clarify the terms of a surrender document. We have in the last 8 to 9 months seen a recurrence of the wheeze, where a tenant simply tries to hand back the keys and trigger a surrender by operation of law. So they send back the keys to the landlord and saying, thanks very much indeed, the lease has come to an end, we'll just send back the keys. Now, the brilliant thing we've seen a few times in the last 6 months is that tenants have sent keys back to landlords' offices or landlords' agents' offices when they know those offices have been closed because of the pandemic or there's a skeleton staff. And so it's sometimes it's not actually recognised for quite some time that actually the keys have been returned. Now, what on earth does a landlord do in these circumstances? Well, you'd be glad to know actually the case law is generally landlord friendly in these circumstances. So simply handing back the keys and taking them back isn't necessarily mean that it's going to constitute a surrender. What we would always recommend is that the landlord should write back immediately to the tenant saying the keys are not accepted and try and return the keys to the tenant. If that's not possible, then you've got to basically look at the landlord's course of conduct having taken back the keys. Does he actually take any proactive steps to affirm that the lease has come to an end? So obviously we've come across things like remarketing in the past. You'd be glad to know, if you're a landlord though, that it's quite difficult to jump over that hurdle in terms of actually the surrender hurdle, because most of the time it will be assumed that the landlord's taken back the keys for safekeeping, particularly if you've tried to communicate with the tenant and let them know that that's the case. There have been instances even when the landlord's gone in and changed the locks for security purposes or kept some sort of security presence on site, and that still hasn't constituted a surrender. The reason why, again, we always look to agree a formal agreement for surrender and deed of surrender is obviously there's always a question about what the terms of the surrender are. What are the implied terms of a surrender? Well, first, of course, the surrender's got to be between all joint tenants, all known tenants, and all known landlords. If a surrender happened by operation of law, for instance, that would keep alive any subtenancies, which I think probably most people know anyway. So basically the superior landlord would become the subtenant's immediate landlord. It would also, though, not necessarily kill off the tenant's mortgage either. So if you are thinking about doing a surrender, it just makes it all the more important to do a full flip through the records and look at the title as well, because the tenant's mortgage won't necessarily die off unless it's been discharged prior to the surrender. With rent as well, the usual position is that obviously with Rent Apportionment Act and the like, that when the rent's paid quarterly in advance, the landlord gets to keep all the rent that it's already had for that quarter, unless there's a written provision in the deed or agreement. And the other thing as well, for landlord's perspective, is to think about service charge as well. That should be formally explicit within the terms of the deed, because sometimes the payments don't happen until certain periods of the year, and obviously there's going to be a question mark as to whether landlords will be able to recover that service charge. And lastly on this bit as well is that even if you accept a surrender by operation of law, so you take back the keys, there is still an ability to go after the tenant for past breaches. So if you disrepair and the like. Obviously, it's better to try and tie these up in a deed of surrender if possible. Maybe having inspected the premises, agreed a figure for the delapse and other breaches. That's always the better way forward. But of course, that's sometimes not possible. And I'll hand back to Chris.
Thanks, Richard. So relevant when tenants are wishing to preserve a bit of cash flow and not spend unnecessary monies on rent. Is obviously to bring the tenancy to an end upon the expiry of the term, or to bring that expiry of the term into effect. So if the tenancy is a rolling periodic tenancy, then a tenant needs to give a valid notice to quit and comply with any common law requirements associated with that, and also any contractual requirements associated with that. The length of the notice will generally depend on the length of the period of the periodic tenancy. So very simply, a monthly periodic tenancy requires at least 1 month's notice to be given, and that notice must also expire generally at the end of the relevant month of the tenancy. A quarterly tenancy requires at least quarter's notice. And of course, getting those notices incorrect means that the tenant might be bound into to the lease and paying rent for a further period, which you would rather avoid. In the context of fixed term tenancies, a tenant needs to be careful if the tenancy is protected by the 1954 Act and if he has security of tenure under the regime in the Act. If it is within the Act, the tenancy will not simply expire at the end of the contractual term unless the tenant has also given up possession on or before that date. And we've obviously seen some of the issues associated with yielding up and delivering possession of the property. So instead, if he has not done that, he will be locked in and liable for rent until he has given a valid Section 27 notice. And that requires a minimum of at least 3 months' notice to be given. General best practice is to ensure that prior to expiry of the contractual term, the tenant gives a Section 27 notice with adequate time to make sure it expires simultaneously with the expiry of the fixed term. That's all I wanted to say in respect of the expiration of the term.
I'll now look at it from a landlord's perspective when you get to normal contractual expiry. So Chris has already touched upon tenant's notice to quit, similar sort of situation where you've got a non-1954 Act protected tenancy, whether periodic or fixed term, in terms of giving notice to quit to make sure the lease expires on the relevant date. Obviously, the complexities come when you throw the 1954 Act into the mix, and obviously almost all of you will know about the Section 25 notices and the counter notices to Section 26 requests. So obviously, if you want a tenant out, you serve a Section 25 notice, a hostile Section 25 notice, giving the tenant 6 to 12 months to vacate, and specifying one of the grounds, which might be one of the fault grounds, such as failure to pay rent or persistent breaches of other covenants, or it might be one of the non-fault grounds, i.e. where the landlord wants to redevelop or take back the premises for their own use. Obviously, remember, if you do specify only non-fault grounds, i.e. you want the premises back or you want to redevelop, then you will have to pay the tenant compensation at the statutory rate of either 1 or twice the rateable value upon getting the premises back. Some of the interesting quirks we've come across recently, there's quite a lot of confusion actually about who serves the notice and who receives the notice. Now, just like the surrender, obviously, it's got to be all landlords serving on all tenants. So if you've got joint tenants, for instance, you need to make sure that notices go to each of the joint tenants. This obviously can be, and if there's a query about this, then obviously the use of Section 40 notices can be used as well to try and gain information about who's in occupation and whether there are any subleases or the like that may need to be dealt with. But from the landlord's perspective, though, the Section 25 notice is meant to be served by the competent landlord, and this sometimes causes some confusion. So the competent landlord must have 14 months or more left of their interest, and otherwise they can't serve the Section 25 notice. Now, where we've come across a couple of quirks about this is dealing with periodic tenancies, which are protected by the 54 Act. So the periodic tenancy needs to be terminated by a notice to quit, and also by a Section 25 notice. Now, the Section 25 notice can work as the notice to quit as well, if phrased in a particular way. And obviously, I'd advise you to get advice on that. The quirk is, though, is that the periodic tenancy has to be terminated by the immediate landlord, whereas the 54 Act statutory tenancy has to be terminated by the competent landlord. That might not actually be the same people, so it might require an element of liaison between the landlord and the superior landlord as to the service of notice to actually get a periodic tenant out. And last but not least on this, don't forget that if you serve a Section 25 notice, you can't withdraw it. You have to play it out, whether by agreement further down the line or by going to court. So just bear that in mind before you serve. Back to you, Chris.
So frustration. This is not a common way of bringing a tenancy to an end, and it will only be in very rare circumstances in which it is available. However, given recent events and mandatory lockdowns, which is preventing many tenants from operating from their premises, their let premises, this has become a very topical principle. And it's something we've been on the receiving end, acting for landlords, where tenants have been trying to put forward this case that the lease has come to an end due to frustration, But recently, we've also been on the tenant side of things, putting forward this argument with varying degrees of success. So in very simple terms, the principle is a contractual one, which provides that a contract will be automatically discharged if a supervening event, which was not contemplated by the parties or by the contract, renders performance of it either impossible, illegal, or radically different from the parties' expectations at the time of the contract, and something which goes to the heart of the bargain the parties thought they struck. Now, in principle, case law tells us that frustration can apply to leases, even though one would think it's a very special type of contract, because it's not simply dealing with personal promises, it creates property interests. The court has, however, decided that a lease can be extinguished by the principle of frustration, and that will bring to an end the leasehold interest. However, case law also tells us that it is only in very rare and unique circumstances in which frustration will be upheld. Now, why is that? Well, few supervening events make either party's obligations under a lease either illegal or impossible to perform. So if we think of a legislated lockdown, which prevents certain businesses from operating from their premises, that does not render the tenant's obligation to pay rent to his landlord impossible or illegal. And also, it doesn't make the landlord's obligations to give the tenant, for instance, quiet enjoyment of his property impossible or illegal. It also doesn't really radically alter the bargain struck. The tenant still has his property and a leasehold interest. And generally, there is some use that he can put the property to. Now, importantly, in the context of leases, is that they normally go on for a number of years. And so one has to look at the duration of the supervening event and the period in which the parties may be hindered in performing their obligations in the context of the full duration of the lease. You know, the tenant, most likely, in the event of a mandatory lockdown, is at some point going to be able to reoccupy it and use it for the use contemplated for a significant period of the term for which the lease was granted. Now, it is possible that frustration might apply to leases which have very specific and inflexible user clauses, and where the residue of the term is short, and so any period during which the tenant is precluded from utilising the premises is much more significant relative to the residue of the term. Now, a tenant would not necessarily be best advised to rely on this principle as extinguishing a lease and providing an exit avenue for him. But it is an argument which a tenant could deploy in the context of negotiating a surrender and to improve the terms of a surrender, rather than strictly relying on this principle and going to court on that basis. That's all I wanted to say on frustration. Over to you, Richard.
It's quite apposite that the previous slide was called frustration, because I'll now go on to forfeiture, and there's certainly a lot of frustration from landlords' perspectives about the restrictions on landlords' remedies in light of tenants' breaches at the moment, and what they can actually do or can't do. And of course, forfeiture is one of those where there is a statutory bar on certain steps at the moment. And that is, as per the slide, governed by Section 82 of the Coronavirus Act. So Section 82 at the moment means that until 31st of December, a landlord can't forfeit for non-payment of rent. So rent is widely defined, basically means all payments under the lease. So it doesn't just mean rent, it means all payments. It's also not linked towards a tenant's ability to pay either. So you might have tenants who might not just be paying, or obviously those who just simply can't pay. It doesn't make any difference in terms of what Section 82 does and the handcuffs it puts on the landlord in terms of not being able to forfeit for non-payment of rent. The Section 82, though, doesn't apply to other breaches, save for non-payment of rent. So you can still potentially forfeit by way of serving a Section 146 notice beforehand if there's been, say, other breaches of covenant, such as massive disrepair or even the tenant going into an insolvency regime. There's not been much going through the courts at the moment, but the general feeling is that even for those other reasons for forfeiture, the courts are going to be very sympathetic to a tenant's plight and will work quite hard to make sure that the tenant can stay in occupation if it wants to. And obviously I mentioned on this slide as well, the right to relief. So even if you can forfeit, there is a right of relief that the tenant or a subtenant or mortgagee can look to exercise if it thinks that it can actually comply with the or remedy the breaches that are specified within the Section 146 notice, or which have actually caused the forfeiture. And last but not least, just quickly, if you do have, it's not forfeiture, but if you have, for instance, an ex-tenant or a licensee who's in essence a trespasser now, it's worth flagging actually that just normal possession proceedings in the courts are now back up and running and have been since 20th of September. So if you want a bit of light reading, then I encourage you to read Part 55C of the Civil Procedure Rules, which kind of specifies the new procedures for simple possession proceedings now against trespassers and the like, and those who have got no legal right to be in occupation. And it's worth a read if you come across any sorts of those scenarios.
So last but not least, I'll talk briefly about disclaimer in the context of liquidation. Now, it's not a readily available way for a tenant of exiting a lease, and it's of course not necessarily a desirable one. But the reason for talking about this topic is that although there's various insolvency mechanisms for ending leases, which might bring about indirectly the end of a lease, and we are seeing lots of those at the moment, particularly acting for landlords who are faced with tenants in administration or liquidation, but the landlords are effectively locked out of getting their property back due to various delays that are going on with administrations at the moment. The reason for talking about liquidation is that it comes with some health warnings and doesn't necessarily provide a complete get out for tenants, particularly in the context of intra-group company guarantees, or where, for instance, directors of tenants have also guaranteed lease obligations. So if, sadly, a tenant is going into liquidation, and that is unavoidable, upon the appointment of the liquidator, he or she will generally disclaim onerous property. So he'll serve a disclaimer notice, and the effect of that is it extinguishes the lease as between the tenant and the landlord and puts a complete stop on the tenant's accrual of liabilities under the lease. Now, the important point here for guarantors and directors who might be providing guarantees is that the effect of disclaimer only extinguishes the lease as between landlord and tenant. But as Hindcastle tells us, the disclaimer does not operate to extinguish the lease or any covenant supplemental to the lease as between the landlord and a third party, such as a guarantor. So if this happens, the lease is notionally preserved for the purposes of a guarantee, and a landlord may still be able to sue the guarantor for rent and other liabilities accruing under the lease, or even if the guarantee agreement provides for it, and many do, bring a claim for specific performance requiring the guarantor to actually enter into a lease for the residue, for a period equivalent to the residue of the term of the lease. So in the context of group companies who might have one entity as tenant and a different entity as guarantor, liquidation and disclaimer, although they might think it's obviously a way of shutting down one tenant business and exiting a significant lease obligation, it might not necessarily provide that complete get out, and another group company might be on the hook. Now, if that is the case, then there's little a guarantor can do or a director can do, short of going into insolvency themselves or negotiating an express surrender with the landlord. Of course, generally, most guarantors do not actually want to step into the shoes of the tenant and take on the lease. So that is all we've got to talk about today. So I'll pass this on to Richard, who will field some questions.
There's been a few sent through beforehand, and also a few that have come through on the live feed. So we'll try and deal with the ones that have come through on the live feed, because we've got 5 minutes or so left of the webinar. So, question about forfeiture and about Section 82 preventing forfeiture proceedings for debt that's racked up prior to March 2020. Now, unfortunately, any debt accrued prior to March 2020 in the incoming of the Act is still caught by Section 82. So if you've racked up debt, if the tenant's racked up arrears prior to March 2020, then we can, so then unfortunately the landlord still can't forfeit for non-payment of rent. There is also a question about carrying minor repair breaches. Yes, you can actually still use forfeiture for breaches of repair, and so Section 82 only refers to forfeiture for non-payment of rent. You still have to go in, inspect, prepare your schedule, prepare a Section 146 notice. You then have to go through the court procedure, and obviously the court would then assess whether the breaches were significant enough as to actually allow you to forfeit or not. So quite often, obviously in repair cases, courts are quite reluctant to grant forfeiture if they could actually be put back in repair within a reasonable period or not. I think generally though, there's been, as I said before, there's been quite a bit of frustration about how firmly the landlord's hands have been tied by various restrictions. There's no winding up proceedings at the moment. You can issue simple court claims for debt. Obviously forfeiture is now restricted. The other thing we found about disrepair as well is that some landlords have you going in and serving Jervis and Harris notices still. So that's where obviously you go in, inspect, and then you serve a notice. And if the tenant doesn't repair in accordance with that schedule, then the landlord can go in and do it itself and recover as a debt. Quite an aggressive move in the current climate, but we've seen it done a couple of times recently. Chris, there's one for you, which is about breaks. And it says, I've got a lease which requires vacant possession for a valid break. However, the break wording then goes on to say, for the avoidance of doubt, any breach of covenant will not prevent the tenant from determining the lease under this clause. What breaches is this likely to be referring to?
Well, that sounds like it's very unfortunate drafting. And I suppose it's a question of interpretation. And I suppose the only way of reconciling that sort of clause with the remainder of the contract and the break clause itself is to read that caveat as being subject to the break conditions. So essentially you treat the break conditions separate to the catch-all breach of covenants. So it's a difficult one, but surely it can't mean that repair covenants have been completely adhered to, because that's generally impossible and a question of fact. But yes, I suppose like I say, it has to be read subject to the specific break conditions. I don't know, what's your view on that, Richard?
Well, I think we're quite lucky now that most modern leases are RICS compliant, and the conditions for satisfying breaks are usually not quite as broad as they used to be. So we used to always come across leases which said that the tenant had to comply with all covenants in order to be able to break the lease, and therefore you were looking at, say, minor breaches of repair covenants and the like, which if they were present at the time the lease terminated, could potentially invalidate the break. So I imagine the kind of avoidance of doubt subclause you've got going on here in this instance, in this question, hopefully means that the tenant won't be able not to exercise the break if there are minor breaches and the like.
Yeah. But I suppose, essentially, the VP condition still has to be adhered to. So yes, I suppose the covenant has to be read as excluding the VP condition. So that still needs to be complied with if the lease is going to end. But yeah, as Richard says, any other breaches of different covenants is not going to prevent the lease coming to an end.
Yeah, That's got to be right, I'd say. We've also just had one through as well about surrender. So in terms of a surrender, does the use of the term "in full and final settlement" offer any protection against further claims by the landlord after the surrender completion date? There's always a few things I look at when we're agreeing a deed of surrender, because of course sometimes obviously the landlords and tenants come up to various deals on what on the payments and what that actually covers. You know, the first thing I look at is make sure that it covers all relevant parties. So obviously, you know, you want to make sure that the landlord doesn't retain any ability to go after previous tenants, original tenants, guarantors and the like. You know, specify within the deed that it is going to be in full and final. It covers not just the parties to the deed, you know, the current landlord and tenant. It covers any other relevant parties as well. The second thing as well is that if you are using the words full and final, you know, make sure you are, you know, sure in your own mind as to what that actually covers. Sometimes in surrenders, you know, obviously it will just refer to delapse, alterations. You know, if there's any chance of any other breaches which potentially might forward a monetary payment from the tenant to the landlord, you know, if you're a tenant, you should be pushing to make sure it covers all breaches of covenant and all covenants within the lease and in relation to do with the premises, just to make sure that you're covered.
Richard, do you want me to pick up the Section 25 notice question?
If you don't mind, that'd be great.
Yeah, so we have a question here. If the Section 25 notice has been served and is due to expire, the parties haven't agreed terms and the tenant hasn't requested an extension, what advice would you give the landlord? So here, obviously, it's a non-hostile Section 25 from the landlord saying, we're happy for you to have a new lease. Here's the terms of the new lease that we propose. Well, it comes down to a question as what does the landlord want? If the Section 25 notice expires and the tenant hasn't issued his county court claim by that date, preserving his right to a new tenancy, then the tenant simply lost his right to a new tenancy. So after that date, the landlord would be entitled to pursue a claim for possession and take back property. Now, it all really depends on, well, is that what the landlord wants to do, or does the landlord really want the tenant to stay there? Now, I suppose my advice would be, if that date has been missed, but you're still, the landlord still wishes to negotiate with the tenant, then you'll probably be best placed to agree a tenancy at will, a very short form document basically saying the tenant remains in there as a licensee only, whilst the parties negotiate the terms of a new lease. If that tenancy at will, if the negotiations break down, then at least the landlord can simply terminate that tenancy at will immediately and take back possession of the property if needs be. But it really comes down to what the landlord wants to do. And I suppose the point is the landlord does need to be careful that if he leaves the tenant in there past expiry of the Section 25 notice, he doesn't do anything which inadvertently creates a periodic lease or something like that, which would then make it difficult to try and get the tenant out if he did want to. So yeah, I think that's my view. Decide what you want to do. If you want to have a bit more time negotiating, put a tenancy in will in place.
Yeah, there's a wealth of case law, isn't there, Chris, in terms of actually whether it's going to be a tenancy at will or a periodic tenancy and how long that should be in terms of after the expiration of lease. There's no hard and fast rule, but just make sure you jump on it as soon as possible is the honest answer. There's just one further question, which I think probably is more suited to you, Chris, and that was, can you explain a bit more about the effect of 1954 Act protection on the operation of breaker clauses? I think that'll probably be the final question for today.
Yeah, so from a tenant perspective, it's not usually a problem because the break notice effectively is a notice to quit and will generally be of a long enough period that it can also act as a Section 27 notice to bring his tenancy to an end and extinguish any security of tenure he has. From a landlord perspective, it is more complicated because if a landlord is exercising a break notice, then what that does is it ends the contractual period and brings the contractual term to an end. But what it doesn't do is bring to an end the 54 Act protection. So for a landlord, exercising a break. He needs to make sure that he's doing a break which complies with the contractual terms, but he's also potentially serving a Section 25 notice at the same time, and the two can be merged into one. Now, of course, for a landlord doing that, the Section 25 notice, if he does want the property back, will have to be a hostile one. And as Richard touched on before, the landlord will need to rely on one of the specific grounds in the Act to affect the termination, whether that's he wants the property back for redevelopment or to resume possession for his own business purposes. Those are things that will have to be done. There are further complications in respect of underlettings. So, for instance, a break notice from a tenant will terminate any underleases beneath him. But if that undertenant has 54 Act protection, then it's going to continue binding the superior landlord. And so the superior landlord might need to think about what he's going to do if undertenants do have 54 Act protection, because he will effectively step into the shoes as the landlord with them. So hopefully that answers the question and gives you an idea of the issues there.
Great. Well, we've finished bang on time. As I said earlier, actually, this is the first in a series of 3 webinars we're doing on subsequent Wednesdays. So the next one's next Wednesday. There are 2 more to go, all about empty space. The next one, we're joined by some of our colleagues in real estate and planning to talk about the repurposing of empty space. And the final one in 2 weeks' time is about what happens to the premises post-expiry of the lease, in particular with relation to dilapidations and alterations. So I hope you've enjoyed today, and I hope you'll join us for the next couple as well. Take care.